Hello from Gainesville, Florida, down in the swamp. I'm here to talk to you today about Mr. Bryan Bancroft. He was a defendant and arrestee by the Gainesville Police Department, Sergeant Loramil. Mr. Bancroft, I'm going to read his arrest warrant to you. On 10/30/2024, the defendant was a patient at the North Florida Hospital located on Newberry Road and committed battery on a security guard ×2. Earlier this same date, at approximately 4:30 p.m., the defendant was discharged and did not agree with that result, so he checked himself into the hospital at approximately 7:30 p.m. The defendant was discharged from the hospital again and refused to leave. Security guard, victim 1 and 2, were wearing uniforms and displaying ID badges, identifying themselves as security officers, went into emergency room number 5 and told the defendant he had to leave the hospital, to which he refused. When victim 1 went to grab the defendant's right arm, the defendant intentionally pulled his arm away and then pushed victim 1 into his chest, against his will. When victim 2 went to go grab the defendant's left arm, the defendant pulled his arm away and then intentionally kicked victim 2 in the groin. Victim 2 was able to gain control of the defendant's arm, but the defendant continued to resist being restrained. The defendant then bit victim 2's left forearm, breaking the skin and causing victim 2 to bleed. Victim 1 and 2 were able to hold the defendant's arm away from the body, and I held his leg. To prevent any further kicking. I witnessed the entire incident, and it was recorded on my body-worn camera. Alright, so here we go. That's the words of Sergeant Loramil. And as you heard, she said that she held his leg because this defendant only had one leg and one hip. He was missing a hip and a leg. He's a cancer survivor. His name is Mr. Bryan Bancroft. And he has a lot of issues. You can imagine being younger and going through all that. Even though he gets a Social Security check, he's not competitive with the rent scale around here, but he seeks this environment to get service because he had his procedure at the University of Florida Shands Hospital. All right, anyway, so this man is in like survival mode. He's miserable. He's contemplating suicide. Now, this hospital is a designated receiving facility. This Sergeant Loramil, this is her permanent post. All right. These security guards in the state of Florida, they're under the authority over them is the Florida Department of Agriculture, Consumer Affairs. That's who issues security guard license. I'll be reading some stuff. I sent a lot of emails to his public defender. Her name is Alexandra Osterman-Burgess, aka Ragedy Ann. I sent emails because this case was like ridiculous. Because first of all, they cannot do what they did, and the paperwork for the discharge was after the fact. Whenever the hospital was in cover your ass mode, the whole thing was preposterous, right? And like I said, there is a policy and procedure for designated receiving facilities to deal with Baker Act patients, or if you're not suicidal, if you're in mental distress, whatever. They have protocol that a psychiatrist is supposed to see you. I mean, they know Bryan. This doctor just wasn't having none. This was doctor generated, okay? But it's all after the fact. Bryan, his attorney, has all the paperwork. You'll see in some of this. This is the case. I already put this. The first part of this case was a case management where Judge Kreider begged Mr. Bryan Bancroft 3 times to take a plea deal, and because the plea offer was made, like, and he could have walked out that day. But instead, Mr. Bryan Bancroft, if you'll hear him, he wants he empowered his attorney to have make a motion to suppress, stand your ground. The attorney did nothing for all this time, and finally in June, she got a stand your ground order. From June to August, he went to court in August to stand your ground, and you're going to hear the argument of Miss Ragedy Ann, Public Defender, Office 8, Public Defender. You're going to hear her argument. This is crazy. Sergeant Loramil was never deposed. Ragedy Ann never went ex parte to the judge and said, look, I'm trying to depose her and I need a show cause hearing because she won't present herself. I've summoned her, twice, was subpoenaed for deposition. Even in this motion to stand your ground, and she is the officer that filed charges, Sergeant Farrah Loramil. She never even came to this. You'll see. She never showed up for this. How do you do this? I think she was either A, Brady listed and couldn't testify, or B, she was going to perjure herself and she didn't show up for that either. But for whatever reason, the public defender, Alexandra Osterman-Burgess, never called that into question. I'm just saying, for whatever reason, attorneys know how to deal with this. I'm not a lawyer. I'm just a lawyer, and I know I found problems in it. Okay, so this never went to anything beyond a big fat no, and you're going to see this. And as soon as Mr. Bryan Bancroft seen his attorney, like he lost confidence in her already, but this was a paramount moment, and he lost confidence. He immediately pled out after this stand your ground hearing. I'm going to read a couple of emails to you. We get free phone calls here. Well, we fought for free phone calls in our jailhouse for the inmates, and so the inmates can call me. They call me. I've been doing this around since March. For whatever reason, they call. If it's just to get in touch with their attorney that hasn't contacted them, blah, 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 for whatever reason, or to do what's outlined here. There is a client, Bryan Bancroft, a year, sitting in jail for approximately 6 months now for a charge that I believe could have been dismissed. I'm aware of the state's plea offer, a charge that allegedly would stem from trespassing, but has no trespassing attachment. This occurred when the alleged victims illegally, unlawfully, but forcefully placed the defendant in a position where, in fear, defended himself. To the fact, when law enforcement intervened, the defendant ceased his actions. This is all on video. In the state of Florida, in which the Department of Agriculture defines security guards may only defend property and life. I have linked the handbook. This is to his attorney. Because she hadn't done anything up to this point. I, by my research, find that the security guard's actions do not even fall into the state's category of criteria to meet the felony charges if they were the ones initiating the physical contact. Law enforcement cannot empower security guards to have police powers. The pretext of the defendant being present in the hospital was to seek treatment. The Baker Act. The defendant was the one who summoned the police. That's who called Sergeant Loramil. Bryan Bancroft summons the police's presence, and he was the perceived victim. A Baker Act. Self-admission cannot be denied in Florida. Anyhow, the outcome, I will be following this case and especially scrutinizing the Public Defender Office, Region 8. 6,000 plea bargains, 500 trials. That's the 2024 statistic. That data was compiled from 2023. And that's, we're going to get the new one soon because it just comes out in, I believe it's August. But 6,000 plea bargains, 500 trials. Imagine that. Now, here's another email that I sent to Ragedy Ann. Bryan Bancroft, his case. You can go into Florida, Alachua County, clerk of the court. You can go look this up, this case. All right. Bryan Bancroft has asked me to convey to you that he demands no more case managements, continuances, that he has not waived his right to a speedy resolution / trial, and that he demands the charges against him dismissed and released from confinement immediately. That would mean 175 days from his October 30th, 2024 arrest. He has informed me that it is his wish to have this recorded in the docket as a correction because he did not specify from the date of his arrest. Not 175 days from April mailing in the docket when informing the court, state, and defense counsel of his demand of a speedy trial. That's one of your rights to a speedy trial. That's one of your constitutional values. To take him to trial would further erode his constitutional values, and it was your fiduciary responsibility, as well as Judge Kreider, to ensure incidents like this do not occur to defendants in your trust. This was all convened to me, the writer, via telephone call with Mr. Bryan Bancroft, inmate at Alachua County Jail, and this is recorded for posterity. Now, I sent her more stuff, like what Florida, like I said in the first one, I sent her the security guard handbook from the Department of Agriculture, Consumer Affairs, all this info that she could have, reacquired by subpoena or however. She couldn't even get the policy and procedure handbook at a hospital. When Bryan, he forced her to have a stand your ground hearing, right? And you're going to see all that in here. So she had to get ready around June for that. But they didn't hold it till August, all right? And it was denied by the Judge Kreider. And you'll see all that in here. Immediately after the stand your ground, the denial, he lost confidence in Ragedy Ann, attorney, public defender, Office 8, Alexander Osterman-Burgess. He lost confidence in her, so he immediately pled out. But you'll see what happened. I mean, he was released that next day. But you'll see what happened. And nothing was ever mentioned. This was a one-legged, no hip, no left leg cancer survivor. This is preposterous what they did to this man. They left him in the jail for a whole year. You'll hear the judge trying to make sense of all this. But when Bryan lost that motion, or when the motion was made for the stand your ground hearing, when he lost that, he was just like, there ain't no way I'm going to trial with Ragedy Ann. So let me wrap this up. This is the 8th Judicial, Judge Kreider, Public Defender Office, Ragedy, a.k.a. Ragedy Ann, Alexander Osterman-Burgess. May God have mercy on your soul if you get assigned her. Oh, and I sent AI overviews, Florida security guard handbooks, all this, the use of force for security guards, the section of the training, quoting 493.61 the Florida statutes, all the articles, everything, 776.031 of Florida statutes, security officers, employer contracted with all the rules that they operate under, with all the links, all that. Mad research. And I emailed all this to Osterman-Burgess, Attorney Osterman-Burgess, Public Defender's Office. And I'm just saying, this is what it came to. And this is our legal system here in Gainesville, Florida, down in the swamp. Thanks for watching. Watch these videos. If you care to ask comments, I'll be more than happy to answer them. Thank you for your time and effort. Bye now.
Is Bryan Bancroft, 2024 CF 3631. Ms. Osterman-Burgess on behalf of the defense and Ms. Gecko on behalf of the state.
Good morning, sir.
Good morning, Your Honor.
All right, where are we at on Mr. Bancroft? Alexandra Osterman-Burgess from Mr. Bancroft, who's present at the podium. Your Honor, we have made a request to the State Attorney's Office for an amended offer. I did not receive a response as to that offer, but did see the state has filed a couple of motions for hearing this morning. I don't know if the state has an answer to that counteroffer. It's willing to put on the record, or we would speak elsewhere.
Your Honor, at this point in time, the state is not willing to negotiate with the defense. They filed or are planning to file a motion to stand your ground. The state believes we either need to have that hearing or set it for trial. At this point in time, I don't believe that we're going to come to a meeting of the minds. As for the underlying charges, the defendant was also charged in the information with the alternative of felony battery repeat offender, which is why the state filed a motion to compel his fingerprints in order to potentially prove that charge if he's found guilty of the lesser included of battery at trial. And so the state would ask for this to the court to grant that motion.
Okay, so the fingerprints motion, yes. What is the state's offer at this point?
One moment, Your Honor. I believe there, at one point in time, the negotiations with the defense was either a straight jail sentence or, in the alternative, probation. So the original offer was to stand silent to adjudication, 36 months probation, credit time served for the amount he's been in jail already, submit to a dual diagnosis for substance abuse as well as mental health, and follow all recommended treatment. Do not return to HCA, no alcohol or illegal drugs, and random screens. At one point, the defense asked for a straight jail time offer, and the state extended 364 days jail.
And he's in 272 days.
I believe so, Your Honor.
That's correct, Your Honor. May I have a
Okay.
moment to discuss with my client?
Yes. What does he score if convicted as charged on the score sheet?
It's 33.6 points.
Okay. Okay.
Your Honor, my understanding from Mr. Bancroft is he does wish to move forward with his case to a stand your ground hearing. I'll get that motion filed.
So let me ask the state, is there restitution?
There's no restitution, Your Honor.
There's no restitution. What's the victim's position on the case?
One moment. Your Honor, the victim stated that he believed that substance abuse was an issue for this defendant, and then other than him trying to get help, he didn't really have a
Okay.
care one way or the other.
And when you get done, sir, you going back to Georgia or are you staying here?
I'm not from Georgia. I'm not sure why.
Why they have Georgia down? Where do you normally live?
I normally live in Fort Myers or up here. That's
Fort Myers or up here?
Yes, sir.
So what do you do down in Fort Myers?
Where?
You got family down there? or it's
No,
just-
that my family moved to Georgia a couple years ago. That's why
Okay.
that one showed up.
Okay. Now, why are you in Gainesville then?
This is where I had my surgery done, so I was seeking better medical treatment up here.
Okay. All right. So the state offers you 364. You have a bunch of misdemeanors. You've never had a felony before, and you've been in 272. You don't score that I have to send you to prison. You sure you don't want to plea open to me today?
Yes, sir.
Yes, sir, you don't want to plea open to me today?
Yes, sir. I do not want to be chief.
Even if you may be going home today and be done with us?
Yes, sir.
Okay.
Your Honor, may I have a moment?
Yes. Yes. Only one. Only count two. Guess we'll do that first, followed by 5 without any penalty. is good. So he still wants to go to trial?
That is my understanding, Your Honor.
Bancroft, I'm going to give you one more pitch.
He's indicated to me he's got some things he'd like to speak privately about, so I
Well,
suggested...
let me make my pitch first.
Yes, sir.
Okay? So my pitch is this. I'm not going to do your trial. I'm at a conference and I'm coming back at the end of the week and I'm going to take a more serious case. When I look at your case, you're what, early 40s?
43, sir.
You don't have any prior felonies. You appear to either have a substitution. If I can make you a convicted felon on this run, it's going to make it more difficult for you to get services in the future. I'm willing to give you one more chance, and I'm willing to be done with you, and the taxpayer is still housing you. The state was offered you 364, you've done 270 something. You've either that's going to keep you from coming back or it's not. So if you want to be done today, you can open plea in front of me right now. If you don't, if you want to keep in the system, you want your stand your ground, which means I probably have to continue your trial. That means you're probably in for another 60 days. You're getting closer and closer to whatever. So that's the strongest pitch I can do.
Yes, Your Honor, I do appreciate it very much. I've been trying to fight this from the beginning of the hospital seeking help, and I don't believe that I did anything necessarily wrong, especially for
So the difficultness that you have is that it's a very high standard to be found not guilty by reason of insanity. So then whether or not you should be guilty or not, arguably what you argue to the jury is what a proper sentence is up to the judge. Did he violate the law by biting them or not? You decide, did he bite them? Did you decide that they warranted being bit? There's probably a good chance that they say they shouldn't have been bit, they're just doing their jobs. They come back guilty, then you put it right back on the judge, depending on the judge you get and what they may learn or learn more, because right now, I don't know that much detail about the bite and all that.
Yes,
But the judge who tries the case is gonna hear all those details, might get upset about that, might decide that you might bite some more people, and you know what? You do score the possibility of prison, and so to make sure, I'm gonna send you to prison.
Yes, Your Honor.
So that's probably why your attorney's probably telling you, you may want to plead today. And I'm telling you, you may want to plead today.
Yes, Your Honor.
So there's, I'm married myself, so I appreciate, sometimes I want to be right, but it's better not to be right. It's better to figure out what's the best course of action to move forward.
Based upon the body camera footage and stuff, I think that I have a case, is all, Your Honor.
Okay? I'm not the one who lives with this. You're the one who lives with it. And only you can make this decision.
Right.
Okay?
Yes, Your Honor, and I do appreciate it very much. I appreciate your time and stuff. The best of my knowledge, I think that the law's on my side in this circumstance. So.
Okay? All right.
Your Honor, if I may just put on the record, if the court is correct, I have advised Mr. Bancroft that, in my opinion, to entering a plea today would be in his best interest, particularly given that the prior negotiation would be for a withhold, and he does otherwise qualify for a withhold of adjudication.
So, sir, it's a decision only you can make. I think you're behind the 8 ball a little bit. I've been doing this for over 30 years, seen a lot of cases, but who knows what a jury may do, okay? So I'm going to take it off the trial docket since your attorney's filing a stand your ground, because there's going to be a hearing for that first, okay?
That was my intention, to go into the stand your ground, Your Honor, and then from there figure out a little bit better where I'm at.
Okay.
And Your Honor, as to the second motion, would the court like to reset that to a different date, or is the court willing
I don't
to-
know why you need his medical records.
So one of the one of the things the state has to prove is that the personnel at the time were working within their line of duty. They had been told that he was discharged from the hospital. The state is just looking for more further proof that they were informed that he was discharged and needed to leave. And so the purposes of the medical records would be to prove that he was in fact completed his treatment and needed to leave the hospital at the time. Then he was also not under any influence of medical drugs that would affect his ability to understand or comprehend what the victims were telling him at the time. And so the state believes that there's enough of a nexus to be able to get his medical records, at least this point in time. Now, if they need to be redacted, if they're going to be used at trial, that would be another story. But at this point in time, the state believes there's at least a nexus to be able to get the medical records.
What says the defense?
Your Honor, I agree with the court that largely the medical records would not be relevant. However, the discharge time, I have no objection to that.
So why don't you limit to the discharge paperwork?
Yes, Your Honor, I can do that.
Okay, all right. All right, so I'm going to continue to the next pretrial conference, which will be on August the 11th, okay?
And Your Honor, will his fingerprints be taken today as well?
Yes,
Okay.
I'll grant the fingerprint.
Thank you, Your Honor.
All right, good luck to you, sir.
Is Bryan Bancroft, 2024 CF 3631. Ms. Osterman-Burgess on behalf of the defense and Ms. Gecko on behalf of the state.
Good morning, sir.
Morning, Your Honor.
All right, where are we at on Mr. Bancroft?
Alexandra Osterman-Burgess from Mr. Bancroft, who's present at the podium. Your Honor, we have made a request to the state attorney's office for an amended offer. I did not receive a response as to that offer, but did see the state has filed a couple of motions for hearing this morning. I don't know if the state has an answer to that counteroffer. It's willing to put on the record, or we would
Your Honor.
speak elsewhere.
Your Honor, at this point in time, the state is not willing to negotiate with the defense. They filed or are planning to file a motion to stand your ground. The state believes we either need to have that hearing or set it for trial. At this point in time, I don't believe that we're going to come to a meeting of the minds. As for the underlying charges, the defendant was also charged in the information with the alternative of felony battery repeat offender, which is why the state filed a motion to compel his fingerprints in order to potentially prove that charge if he's found guilty of the lesser included of battery at trial. And so the state would ask for this to the court to grant that motion.
Okay, so the fingerprints motion, yes. What is the state's offer at this point?
One moment, Your Honor. I believe there, at one point in time, the negotiations with the defense was either a straight jail sentence or, in the alternative, probation. So the
Okay.
original offer was to stand silent to adjudication, 36 months probation, credit time served for the amount he's been in jail already, submit to a dual diagnosis for substance abuse as well as mental health, and follow all recommended treatment. Do not return to HCA, no alcohol or illegal drugs, and random screens. At one point, the defense asked for a straight jail time offer, and the state extended 364 days jail.
And he's been in 272 days.
I believe so, Your Honor.
That's correct, Your Honor. May I have a
Okay.
moment to discuss with my client?
Yes. What does he score if convicted as charged on the score sheet?
It's 33.6 points.
Okay. Okay.
Your Honor, my understanding from Mr. Bancroft is he does wish to move forward with his case to a stand your ground hearing. I'll get that motion filed.
So let me ask the state, is there restitution?
There's no restitution, Your Honor.
There's no restitution. What's the victim's position on the case?
One moment. Your Honor, the victim stated that he believed that substance abuse was an issue for this defendant, and then other than him trying to get help, he didn't really have a
Okay.
care one way or the other.
And when you get done, sir, you going back to Georgia, or you staying here?
I'm not from Georgia, I'm not sure why.
Why they have Georgia down? Where do you normally live?
I normally live in Fort Myers or up here. That's
Fort Myers or up here?
Yes, sir.
So what do you do down in Fort Myers?
Where?
You have family down there? Or it's
No,
just-
my family moved to Georgia a couple years ago, that's why
Okay.
that one showed up.
Okay, now why are you in Gainesville then?
This is where I had my surgery done, so I was seeking better medical treatment up here.
Okay, all right. So the state offers you 364. You have a bunch of misdemeanors. You've never had a felony before, and you've been in 272. You don't score that I have to send you to prison. You sure you don't want to plea open to me today?
Yes, sir.
Yes, sir, you don't want to plea open to me today?
Yes, sir, I do not want to be chief.
Even if you may be going home today and be done with this?
Yes, sir.
Okay,
Your Honor, may I have a moment?
yes. Yes. Only one. Only count two. Guess we'll do that first, followed by 5 without any penalty. Life is good. So he still wants to go to trial?
That is my understanding, Your Honor.
Bancroft, I'm gonna give you one more pitch.
He's indicated to me he's got some things he'd like to speak privately about, so I
Well, let me
suggested.
make my pitch first.
Yes, sir.
Okay? So my pitch is this: I'm not gonna do your trial. I'm at a conference and I'm coming back at the end of the week and I'm gonna take a more serious case. When I look at your case, you're what, early 40s?
43, sir.
You don't have any prior felonies. You appear to either have a substitution. If I can make you a convicted felon on this run, it's gonna make it more difficult for you to get services in the future. I'm willing to give you one more chance, and I'm willing to be done with you, and the taxpayer is still housing you. The state was offered you 364, you've done 270 something, you've either that's gonna keep you from coming back or it's not. So if you wanna be done today, you can open plea in front of me right now. If you don't, if you want to keep in the system, you want your stand your ground, which means I probably have to continue your trial. That means you're probably in for another 60 days. You're getting closer and closer to whatever. So that's the strongest pitch I can do.
Yes, Your Honor, I do appreciate it very much. I've been trying to fight this from the beginning of the hospital seeking help, and I don't believe that I did anything necessarily wrong, especially for
So the difficultness that you have is that it's a very high standard to be found not guilty by reason of insanity. So then, whether or not you should be guilty or not, arguably what you argue to the jury is what a proper sentence is up to the judge. Did he violate the law by biting them or not? You decide, did he bite them? Did you decide that they warranted being bit? There's probably a good chance that they say they shouldn't have been bit, they're just doing their jobs. They come back guilty, then you put it right back on the judge, depending on the judge you get and what they may learn or learn more, because right now, I don't know that much detail about the bite and all that.
Yes.
But the judge who tries the case is gonna hear all those details, might get upset about that, might decide that you might bite some more people, and you know what? You do score the possibility of prison, and so to make sure, I'm gonna send you to prison.
Yes, Your Honor.
So that's probably why your attorney's probably telling you, you may wanna plead today. And I'm telling you, you may wanna plead today.
Yes, Your Honor.
So I'm married myself, so I appreciate, sometimes I wanna be right, but it's better not to be right. It's better to figure out what's the best course of action to move forward.
Based upon the body camera footage and stuff, I think that I have a case, is all, Your Honor.
Okay, I'm not the one who lives with this. You're the one who lives with it. Only you can make this decision.
Right.
Okay?
Yes, Your Honor, and I do appreciate it very much, appreciate your time and stuff. I just, the best of my knowledge, I think that the law's on my side in this circumstance. So.
Okay, all right.
Your Honor, if I may just put on the record, if the court is correct, I have advised Mr. Bancroft that, in my opinion, to entering a plea today would be in his best interest, particularly given that the prior negotiation would be for a withhold, and he does otherwise qualify for a withhold of adjudication.
So, sir, it's a decision only you can make. I think you're behind the 8 ball a little bit. I've been doing this for over 30 years, seen a lot of cases, but who knows what a jury may do, okay? So I'm going to take it off the trial docket since your attorney's filing a stand your ground, because there's going to be a hearing for that first, okay?
That was my intention, to go into the stand your ground, Your Honor, and then from there figure out a little bit better where I'm at.
Okay.
And Your Honor, as to the second motion, would the court like to reset that to a different date, or is the court willing
I don't
to-
know why you need his medical records.
So one of the one of the things the state has to prove is that the personnel at the time were working within their line of duty. They had been told that he was discharged from the hospital. The state is just looking for more further proof that they were informed that he was discharged and needed to leave. And so the purposes of the medical records would be to prove that he was in fact completed his treatment and needed to leave the hospital at the time. That he was also not under any influence of medical drugs that would affect his ability to understand or comprehend what the victims were telling him at the time. And so the state believes that there's enough of a nexus to be able to get his medical records, at least this point in time. Now, if they need to be redacted, if they're going to be used at trial, that would be another story. But at this point in time, the state believes there's at least a nexus to be able to get the medical records.
What's his defense?
Your Honor, I agree with the court that largely the medical records would not be relevant. However, the discharge time, I have no objection to that.
So why don't you limit to the discharge paperwork?
Yes, Your Honor, I can do that.
Okay, all right. All right, so I'm going to continue to the next pretrial conference, which will be on August the 11th, okay?
And Your Honor, will his fingerprints be taken today as well?
Yes,
Okay.
I'll grant the fingerprint.
Thank you, Your Honor.
All right, good luck to you, sir.
Yes, Your Honor. Pamela Geckel on behalf of the state. We're here on case number 2024 CF 3631, State of Florida versus Bryan Bancroft. The attorneys of record are Ms. Osterman-Burgess on behalf of the defense and Ms. Geckel on behalf of the state. And we're here before the court for the defendant's motion to dismiss, a stand your ground motion, Your Honor.
Okay, all right. And the case is set for jury selection on Tuesday, correct?
That's correct, Your Honor.
Okay, and it looks like it's going to be Judge Brewer on Friday, September the 5th, trying the case.
So it's a Friday trial, Your Honor?
It's Friday trial. Yes. All right. State ready to proceed?
The state's ready, Your Honor.
Okay.
If I may, Your Honor, at the end of this hearing, there is a possibility that the defense might move to continue for purposes of obtaining a transcript and an outstanding response on a subpoena, but we are prepared to move forward with the hearing today.
Okay, is there an offer from the state in this case?
Your Honor, the last time that we had any conversations about a potential offer, the state presented 2 offers to the defendant, either a probation offer or a straight jail sentence, neither of which the defendant was interested in accepting.
Okay. And does he have any prior felony offenses?
No, Your Honor.
Okay. All right. All right, State, you ready to call your first witness?
Yes, Your Honor. I do just want to make sure I place on the record before I call my first witness that upon reviewing the defendant's motion and specifically their statement of facts, there are a few of those paragraphs that the state is specifically disputing as that we don't believe that's a factual or an accurate factual representation of what occurred, but we can address that further when the argument portion is addressed.
Okay.
At this point in time, the state calls James Handley. Handley.
Your Honor, for purposes of this hearing, may we invoke the rule of sequestration?
You can. How many witnesses do you have, Ms. Geckel?
2, Your Honor.
Can you just explain to your witnesses the rule of sequestration has been invoked?
Yes, Your Honor. Just before I come in, I just need to explain. I told you this earlier. No, I don't. Until you would go, yeah.
Once you step while you walk out there, remain standing and be sworn in.
Good afternoon. Raise your right hand for me. Swear affirm the testimony that gives me the truth, the whole truth, and nothing but the truth.
I do.
Please be seated, sir.
Thank you.
May I proceed?
Yes, please.
Could you please state your name and occupation for the record?
James David Handley. I am a sergeant for Allied Universal Security.
So I'd like to take a moment and really talk about your employment history, specifically with Allied, and your position as a security officer, okay?
Yes, ma'am.
So you stated that your current position is a sergeant with Allied, is that correct?
Yes.
And how long have you held the position of sergeant?
6 months.
And in total, how long have you had employment with Allied?
Over 2 years.
Okay. Now, dissecting that a little bit further, is it correct to say that you've been with Allied on and off over those 2 years?
No, this is 2 years, probably 2 years straight, on and off. I've been with them since about 2018.
Okay, so on and off since 2018, but currently you've been with them for 2 years?
Yes, ma'am.
Now, you are a licensed security officer?
Yes, ma'am, I am.
How long have you been licensed for?
Hang on.
Take your time.
Approximately 10 years.
Is there some sort of training or class you have to take in order to be a licensed security officer?
Yes, ma'am. Pursuant to Article 493, we have to take a 40-hour class to initially get our Class D security license.
And so is it possible for you to hold a position as a security officer without actually being licensed, at least as an employee of Allied?
No.
And at the time of this incident, October 30th of 2024, were you still an active license holder for a security officer?
Yes.
Okay. Now, you're employed with Allied, correct?
Yes.
What is Allied relationship with HCA North Florida?
We are a contractor for security for HCA, North Florida.
Is there actually a written contract between Allied and HCA?
I'm sure there is.
Okay.
Above my pay grade, but I'm sure there is.
Well, were you explained that when you accepted the job at Allied, that there was a contract between them and
Yes.
HCA? And how long have you been stationed at HCA as an employee of Allied?
Approximately the 2 years.
Okay. Is there policies and procedures in place between Allied and HCA as far as your duties and responsibility of a security officer?
Yes.
Can you explain some of those duties and responsibilities?
As far as we control Baker Acts, we control trespassers, we do door unlocks, gate unlocks. We ensure the stability of the hospital.
Are you ever called by employees of the hospital to assist in interacting with patients?
Oh, yes.
What instances have you been called to interact with those patients?
I have been called for extreme violence all the way to Alzheimer's disease who just want to leave and don't know where they're at.
Have you ever had to handle someone who was discharged from the hospital and was refusing to leave?
Yes.
Is that also within your capacity as a contract with HCA?
Yes.
When you approach a patient who has been discharged but refusing to leave, what are some tactics or actions that you take to try to address the situation?
Well, needless to say, our very first step is de-escalation techniques. We try to explain We're private property. The doctor has discharged you. It's time to go. You can no longer be here. This is private property. And we will do everything in our power, everything from, we'll try bribery, snacks, rides, drinks. I will grab a wheelchair, I'll take you out to the bus stop. We'll try every technique we can do to make sure that you can leave the hospital functionally.
Now, is it common for a sworn law enforcement officer to be stationed at the hospital as well?
Yes,
Is there normally one present during your shifts?
yes,
And what is the purpose of their presence?
to assist security.
Does their standing as a law enforcement officer supersede or trump your authority as a security officer of the hospital facility?
No,
Okay. Are you allowed to arrest any individual?
no,
All right. In your policies and procedures, do they have information on if you're allowed to use any type of force or hands-on procedures?
yes.
Can you briefly explain that?
We're allowed to use soft hand techniques to defend ourselves
Okay.
or hospital staff.
What are some soft hand techniques?
Holding down, making sure they don't swing, making sure they don't bite.
Are you allowed to use similar soft hand techniques when assisting a patient who has been discharged but refusing to leave?
Yes.
Okay. I want to turn your attention now to October 30th of 2024, specifically in regards to a patient by the name of Bryan Bancroft. Do you remember that incident?
Yes.
Do you recall about what time you were radioed to address Mr. Bancroft?
Approximately 7:30 p.m., 1930.
Okay. When you arrived, and do you know where he was, do you know where his room was at in the hospital?
Yes, ma'am. He's in emergency department, room 6.
Who responded to that call?
Myself and Officer Davis.
When you responded to the room, did you confirm with anybody that he in fact been discharged?
The house supervisor.
Okay. Is this something you commonly
Objection,
do?
Your Honor, hearsay.
Overruled.
Is this you can answer the question. Do you, did you confirm with somebody that he had been discharged?
The house supervisor.
Is this something that you commonly do?
Yes.
And you recalled having that conversation that evening?
Yes.
After that point that you had confirmed that he had been discharged, do you have any interactions with Mr. Bancroft?
Yes.
What were the interactions you had with him?
We attempted to escort him out of the building.
What were some of the procedures or techniques that you use in this specific case?
Like I said, we tried de-escalation techniques. He refused to leave without obtaining a prescription. So we instructed him that he had to leave one way or the other, and that's when I called Lima 1 in, which
And-
is our law enforcement officer.
Objection, Your Honor, hearsay.
Overruled.
And what is Lima 1?
Lima 1 is our GPD officer that's on staff.
Do you recall who was on staff that evening?
Sergeant Loramil.
Okay. Once Sergeant Loramil arrived, describe the interactions that proceeded after that point.
At that point, the patient had his foot propped up on top of the brace for the beds, so we couldn't let the bed rail down to assist him out of the bed. So I gently moved his leg over so it wouldn't get caught when we pulled the bed rail down, and it went downhill from there.
Okay. So I want to break that down just a little bit.
Okay?
So at some point in time, you enter Mr. Bancroft's room.
Yes.
Is it just you by yourself?
No. Officer Davis was there with me.
Okay. When you enter the room, What is it that you are doing when you enter the room?
When I first entered the room, I let the bed rail down on the side that I was on.
Okay, and what was Officer Davis doing?
Officer Davis was attempting to let the bed rail down on the side he was on.
Okay, did you notice if he was having a hard time with that?
Yes, he was having a very hard time when I walked over to assist.
Okay, and describe one more time, why was Officer Davis having a hard time putting the bed rail down?
Because the defendant had his foot stuck on the rail and was pushing it up so we couldn't let the bed rail down.
Okay. After you realize that the defendant had his leg stuck on the bed rail, what is it that you do?
I moved his foot.
Is there any communication with him when you're moving his foot?
No, not really, just move your foot.
Okay, just basically saying move your foot.
Yes.
Okay, and once you move his foot, what happens from there?
I believe at that point, the patient decided to start kicking.
Okay, did he issue any threats prior to him kicking?
I believe he said he was going to kick my ass, yes.
Okay. Do you recall if this interaction was captured on any sort of video?
Yes.
What video was that?
GPD's body cam.
Have you had a chance to review that video?
Yes, I have.
May I approach the clerk, Your Honor?
We may.
May I approach the witness?
We may.
All right, sir, I'm showing you what's been marked for identification purposes as State's Exhibit A. Do you recognize State's Exhibit A?
Yes.
What is it?
That is the USB drive of the body cam footage.
Did you have a chance to review that?
Yes, I did.
Is it a fair and accurate representation of the interactions that happened once you entered the room of Mr. Bancroft?
Yes, it is.
At this point in time, Your Honor, the State moves into evidence State's Exhibit A.
Any objection?
No, Your Honor.
Okay, at least states one in evidence.
May I play the video, Your Honor?
Yes.
So I want to pause the video in just the very beginning for just a moment. Could you please, at the top of the screen, read what time Sergeant Loramil is heading towards the patient's room?
2024, 10:30 at 1928.
1928?
That's 7:28 p.m.
Okay. At this point in time, have you guys had any sort of interactions with Mr. Bancroft?
Yes, we've been trying de-escalation. We've been advising him he's been discharged. It's time to go.
Okay.
What can we do to help?
Mr. Bancroft, what's going on?
You told me to come date back myself, and I haven't seen a psychiatrist yet.
I told you to check yourself back in because you were the one that were making the statements about what it is you're going to do. Okay, and I completely get that, but at this point, you're already at the receiving facility, and if they've done what it is that they're saying that they can do, if they have done, because I wasn't here for the step-by-step, so you gonna let me talk? You're what happened?
I do know what's going on, and I'm not a liar.
I never said you were.
I'm warning you that that's not the case, so when you attempt to make me feel stupid,
I wasn't trying to make you feel
just
stupid.
warning you to explain things that I already know.
I wasn't trying, so what I'm trying to explain to you is that based on this, if they're saying that you've received treatment, if you are not satisfied with the treatment that you have received here, you are more than welcome to go to another location for treatment. But if they're saying, like she was just saying before, that you have received your treatment, what else do you feel that you need to be treated for? So, what else do you feel that you need to be treated for? For pain? Okay. So he said he's still in pain.
They've already discharged you, he's gonna have to check back in anymore.
Okay. So, you're not gonna. So he's not gonna get any.
So, all right. So you're gonna have to go ahead at this point. You're gonna have to get up and get out, man. I'm sorry to tell you that.
They're saying that they're not gonna give you any more pain medication. So what happened the first time that you were here?
They discharged me after lunch, after ER doctor, acted like the psych doctor, overrode the psych doctor. And then they discharged instead, I discharged myself and attempted to, that's when I was trying to get a hold of the bank so I could get my money. But I still can't do that, you see, so I'm still in the same position we were in when I came to check myself in, and Dr. Henderson, and he never let me see psych. And he ran off before I could report his suggestion that I take the psych meds that would make me pass out, go outside and pass out in the parking lot with us, just because he knows that would just get me out of his hair. And as I tried to get him to say that, he walked off.
So what would you like to do? Because you're not getting the appropriate care that you feel that you need. Okay, so you don't feel that you're getting the appropriate care that you need at this particular facility. And based on what it is that she's saying, that they're not gonna give you anything else while you are here. Would you like me to call somebody for you to transfer you to another facility? Okay, and who am I calling?
I didn't say that to me. That's why I got it. He said he been banned from this. He said he been banned from this.
Sorry? Okay, so, do you wanna go to Meridian? Why not? No, actually I didn't, that's why I'm asking you, why can't you go? I don't know why you can't go to Meridian, sir.
Because I'm prescribed narcotics, and they don't distribute narcotics. They don't distribute narcotics.
Okay, they're not gonna give you any narcotics here.
I'm not trying to get.
You're not getting none here. That's all you gotta say. You gotta go.
Okay, so we can try to get you somewhere else.
Mr.
Bancroft.
You hurt me.
You think you can hold my left leg here a little bit? You see that thing right there?
Alright,
Sir, I'm gonna get first.
so, you've been discharged from high school? Stop. Mr. Bancroft, stop. Mr. Bancroft, stop.
I'll drop the charges right now.
That's fine.
Stop kicking! Stop kicking! Stop! 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 Stop!
No, you're not trying to choke you. I'm not trying to choke you.
Stop! You're not gonna try to fight. Mr. Bancroft, stop doing this! Stop! Stop! Stop!
So I'm going to pause at this point in time. Can you please read the time of the video that it's currently paused at?
1934.
Okay. So when we first see you go into the room of Mr. Bancroft, it was as you described, right? You put the side of the gurney down on your side and then head over to Mr. Davis. At that point, you had attempted to remove the defendant's leg from where he had intertwined it with the gurney. Is that correct?
Yes.
And then once you had a hold of his leg, what happened after that?
I let go of his leg.
So,
I was done at that point. I moved it. I let go of his leg and walked up to towards the head of his body.
well, so let me rewind it one more time, because I have a question about that.
Okay.
Okay, so we'll just start from here.
They don't distribute narcotics. They don't distribute narcotics out here.
They're not gonna give you any narcotics here.
I'm not trying to get
You're not
narcotics.
getting none here. That's all
You're
you're
gonna
gonna
pay
say.
for it.
You gotta go.
Okay, so we can try to get you somewhere else. Mr. Bancroft.
Okay, so you described that you removed his leg from the side of the gurney, but then it does appear in the video that you are continuing to hold on to his leg. Can you describe to us why you're doing this at this point in time?
To keep him from kicking me.
And why were you concerned that he was going to kick you? Did he say anything to you at that point in time that said that he was going to kick you?
He said he was going to kick my ass at that point.
Okay. And so that's why you have a hold of his leg. Where are you positioned at in this video, where his, as far as where his leg is and where you're positioned?
Where I'm positioned at the foot of the bed.
Is that directly where his leg could kick you?
Yes.
Okay.
Oh, you hurt me,
You
will
think
be
it's all my left leg, you will be, you
You
see that man right there?
Sir, I'm gonna
You been discharged from my
And so, at what point in time do you let go of his leg?
When he quit resisting.
Okay, and so you felt safe at that point in time to release his leg and then do what? What was your next?
I was walking up to the front where his arms were.
Okay. At that point in time, had you had any opportunity to offer to get a wheelchair or offer to get his crutches?
No.
At that point in time, you had only merely just attempted to put the sides of the gurney down, is that correct?
That's all we were doing at that point.
In that situation where you were holding on to his leg, did you feel that he was either going to harm himself or others?
He was going to harm others.
And who were the others that he was going to harm?
Myself or Officer Davis.
Okay. May I have a moment, Your Honor?
You may.
And so after you let go of his leg, is that when he kicked you?
Yes.
And when he was kicking you, how did you respond to that?
I told him he was going to be a felon, and I grabbed his leg, and we kept him from kicking me again.
Again, the purpose of grabbing his leg was to keep him from kicking you, is that correct?
Yeah, I didn't want to get kicked again.
All right. Did you, at some point in time, let go of his leg again?
Yes.
And did he continue to kick you?
Yes.
All right. Where did he make contact with your body?
In the groin area,
Any other places?
in the chest.
After you attempt to I guess, hold his leg, did he batter you in any other way?
Yes.
What other ways?
He swung at me, he
All right.
spit at me, and he bit me.
Okay. Did he spit at you before or after he bit you?
After.
Okay. Were your actions in this scenario or in this incident, were they within the lawful duties as your position of a security guard at North Florida?
Objection, Your Honor, invading the province of the court.
Overruled.
You can answer the question.
Yes, it was within my scope of responsibility.
Okay. No further questions.
Okay, cross.
Good afternoon, sir.
Good afternoon.
So you radioed for assistance at 7:30 p.m., you said?
Yes.
And you were in ED 6, room 6 in the emergency department?
Yes, I was.
My understanding is that the officer Loramil or Sergeant Loramil was already stationed at the hospital, is that right?
Yes.
And she was just down the hallway when you radioed for her help?
I do not know where she was at that point. That's why I radioed.
Oh, she's normally stationed in the ER, is that right?
No, she's normally stationed out front of the ER in her car.
Just outside the front door?
Yes.
And you said you work for Allied Universal Security Services?
Yes.
You're an employee of that company?
I'm sorry?
You're an employee of that
Yes,
company?
I am.
All right, and you're licensed as a security guard under Chapter 493?
Yes.
You're aware that you can face discipline on your security guard license for use of force?
Yes.
And that includes if you were to use or engage in an act of violence or use of force against someone outside of protecting oneself or someone else?
Yes, fully aware of that.
There are, outside of protecting someone or oneself, there's no kind of allowance for you to use that type of force against a person.
No.
At the time that you interacted with this individual in the emergency department, you did not receive a threat at the time that you first walked in the room.
No.
And at the time that you first touched this individual, as we see on the video, there was no threat made at that time.
Not at that time.
There was no offer of violence in any way,
Not at that time, no.
to yourself or to anyone else.
No.
As we can see from this video, Sergeant Loramil, the police officer, is present while you are interacting with this individual.
Yes.
And that officer, at no time do we hear you ask for her assistance.
No.
And you never, you never offered to assist this individual in getting out of the hospital bed.
Yes, we did, but that's not on camera.
What we see on the camera, you never offer that
No.
assistance.
Not on camera.
And this whole interaction lasted within 5 minutes,
Approximately.
approximately, even perhaps as little as 2 minutes.
No, approximately 5.
You weren't personally aware of the individual's discharge status, is that right?
Is what?
You were not personally aware of the discharge status, whether or not discharge had occurred.
Nothing other than what the house supervisor told me.
Yeah. You were not personally aware.
We don't usually go with medical records. We're a subcontractor for HCA.
At the time that you entered the room that we see on the body camera video, that was the first time you entered the hospital room?
No.
And at the time we see you enter the hospital room on this video, at that time, you did not offer assistance to the individual.
Objection asked and answered.
Overruled.
You may answer.
No.
And in fact, you didn't spend long enough interacting with this person to notice that he had one leg.
No.
No, you did not?
No.
At any time, you never offered or asked Sergeant Loramil to trespass this individual during this time?
No.
And you are aware that had you done so, that Officer Loramil would have had the authority to arrest had the individual refused to leave?
Yes.
Your Honor, may I have a moment?
You may.
To clarify, sir, you mentioned earlier that there exists a contract between HCA North Florida and Allied Universal,
Yes.
but you are not aware of what that contract says,
No, ma'am.
and you don't have access to a copy of it.
No, ma'am.
I have no further questions.
Okay, any redirect?
Just briefly, Your Honor. As far as your personal knowledge of his discharge, to be clear, you didn't read the discharge. You didn't read a piece of paper saying you'd been discharged, right?
No, I did not.
But you spoke to somebody.
Yes.
And you spoke to somebody who you knew because of your, as your status of somebody who works there regularly, who was in charge and be able to tell you for sure this person had been discharged. Is that
Yeah.
correct?
Objection, Your Honor. Hearsay.
Overruled.
I think you described the person as house. What did you say the position of the person was that told you?
It's house supervisor.
Okay. You also mentioned in cross that there was a time that you had offered assistance for Mr. Bancroft to come out of that bed. Is that correct?
Yes.
But that's not captured on the video.
No.
Do you know about how many times you had offered assistance to kind of get him out of that bed?
Once, approximately once.
Okay. And you weren't looking for him to be arrested for trespass, were you?
No,
Okay. You were just asking him to leave the premises.
just leave the premises.
No further questions.
All right, sir, if you'll have a seat outside, please. Is the witness free to go or subject to recall?
Subject to recall, Your Honor.
All right, if you'll have a seat outside, please, sir.
Yes, sir.
Call your next witness, state.
State calls Jeremy Davis.
Watch your step, remain standing as sworn, please.
Good afternoon. Raise your right hand for me. Swear affirm a testimony that gives me the truth, the whole truth, and nothing but the truth. Please be seated, sir.
Good afternoon. Could you please state your name for the record?
Jeremy Davis.
Mr. Davis, in October of 2024, were you an employee of Allied?
Yes.
And what is the full name of Allied?
Allied Universal Security.
What was your position with Allied Universal Security?
I was a security officer.
Did you complete the required hours and necessities to become a licensed security officer?
Yes, ma'am.
All right. And how long did you work with Allied in the capacity that you were assigned to HCA North Florida?
10 months.
During that time, were you aware or did you understand about the contract that that Allied Universal had with HCA North Florida?
Yes.
Okay. Did you understand your duties and responsibility as a contractor with HCA?
Yes.
During your employment at the hospital, did you ever have to deal with patients who had been discharged but refusing to leave?
Yes.
And have you had to escort them off the property?
Yes.
Now, I want to ask you a few things about what kind of techniques or things that you use when someone is refusing to leave. Could you please describe that to us?
Well, the first one is just presence. Level 1 is presence. Just show up and hopefully they go ahead and just get up. The second level is verbal. And that's, of course, we asking them and explaining to them why they have to leave you know, and then sometimes we'll show them the discharge papers just to verify, because sometimes they'll say that they haven't been cleared to leave, and we'll get the paperwork and show it to them. And the third level is soft hand, basically guiding them, you know, to leave, soft hand or restraining if they decide to start getting combative.
Okay. I want to go back to the part where you said you'll show them discharge papers, and I want to refer you to this specific incident in October with Mr. Bancroft. Did you respond to that call for security officer for Mr. Bancroft's room?
Yes.
At any point in time, did you have a verbal conversation with Mr. Bancroft?
Yes.
At any point in time, did you show him his discharge papers?
Yes, I did.
Okay. On those discharge papers, does it have a date and time that he was discharged?
Yes.
May I approach the clerk, Your Honor?
You may.
May I approach the witness?
Yes.
Okay. I'm sorry, Your Honor, can I actually approach defense counsel? Just the date and time. Yeah, that is at this time, Your Honor, state is moving to enter into evidence State's Exhibit B. The State's Exhibit B is the defendant's discharge medical records with a certified medical records certificate showing that it qualifies as an authenticating document under 90.803 subsection 6 subsection C.
Any objection?
Yes, Your Honor. The documents refer to contain testimonial hearsay, which, as far as I am aware, do not have a hearsay exception to be admitted.
So under the business record, did you file an objection to the business records coming into evidence?
Your Honor, I received them very late yesterday afternoon. I apologize, I did not have time to draft such an objection.
Okay. So I'll overrule the objection. They can come in for purposes of this hearing.
And so now they're entered into State's evidence as State's Exhibit 2. No, no, no. Mr. Davis, I have before you what's been marked in evidence as State's Exhibit D. Could you do me a favor and just read into the record? I'd like you to first read the first two words that are in bold print there.
Oh, discharge plan.
And underneath the discharge plan, does it give you a date of discharge as well as a time of discharge?
Yes, it does.
Can you please read off the date of discharge?
10/30/24.
Could you please read off the time of discharge?
19:20.
19:20.
19 hours.
So is that military time?
Yes.
So I guess standard time, that would be 7:20 p.m.
Yes.
And so you made Mr. Bancroft aware that he had been discharged and then showed him the discharge papers.
Yes, that's correct.
At that point in time, after you had done both those things, did he get up and leave the hospital?
No, he refused.
At some point in time, did a GPD officer respond to the scene?
Yes, once I called him.
Okay. Did you make him any other offers to help him or assist him in leaving the property?
Yes.
What kind of offers did you make to him?
I told him that because he said he didn't have nowhere to go. And I told him, well, we can call a taxi for you and we can actually give you a voucher and they'll take you where you want to go, somewhere you need to go. And we told him we can go to Meridian, and he can go to Vista. And at the time, he stated that he didn't want to go there because they didn't give him narcotics or something like that. They wouldn't issue him narcotics.
Even though he couldn't go to Meridian or Vista, did you still let him know that the taxi will take him any place he wants to go?
Yes, I did.
Did this conversation take place before Sergeant Loramil gets there?
Yes, that was before the Sarge got there.
And in fact, what's showed on the screen before you is the video of Sergeant Lamil's body cam that's been entered into evidence. I believe in the body cam you even tell Sergeant Lamil that's what he said before when she brings up transporting him someplace.
Yes, she also said the same thing that we said. She can actually get him a ride somewhere.
All right. And after Sergeant Loramil comes, are you guys still trying to talk to him and explain to him that he needs to leave, he can't stay there?
Yes.
All right. What is his reaction or what is his body language when you guys are telling him over and over again he can't stay there?
The same thing, just over and over. I can't go nowhere. I don't have nowhere to go. I don't have nowhere to go. And I was like, well, you have to, we need the room. Other patients are waiting, so, you're going to have to go. We got to escort you out. We don't want to trespass you, so, you got to get up and go.
Okay. So you just said something there, we don't want to trespass you. Is that correct?
That's correct.
Is that a part of other techniques that you guys use to let them know we just need you to leave?
Right. That's correct.
Okay. And then at some point in time, you do enter the room with Mr. Hanley, is that correct?
That's correct.
And what happens when you enter the room with Mr. Hanley?
We're in the room, we go ahead and do the soft hand, basically guide him, or try to guide him out, but we had to let down the bars on the side of the bed, and he was holding it with his foot. He was holding it with his leg, and basically I was telling him, hey, can you move your leg for you, don't want to hurt you, don't want to hurt your leg. The same thing is like if a kid had a hand in the door, you about to get ready to close the door, you see their hand, you say, hey, watch out, I don't want to hurt your hand.
Okay.
So they'll move their hand and, then you can go ahead and proceed.
And did he move his foot?
Not willingly, no.
And so who moved his foot out of the way?
Hanley moved it, yes.
Okay. Do you recall what happens after that?
After Hanley grabbed it, then I went ahead and put the bed rail down, and then he held on to the bed rail. And
so you put the side that you're on, you put that bed rail down.
yes.
When you put that bed rail down, he then grabs onto it?
Yes, he grabbed onto it to hold on, I guess, to basically say he's not moving willingly.
What did you do when he grabbed onto the handrail?
I grabbed his arm and pulled it up.
Okay.
Pulled it off the bed rail.
To get it off the bed rail.
Yes.
At any point in time, did you guys get far enough to offer him a wheelchair or his crutches?
Yes, we did. We offered him his crutches, and we said we can get you a wheelchair too.
Was that before Sergeant Lamel arrived?
That was before, yes.
Okay.
That was before.
But not once you guys are in the room moving the bed rails down, is that correct?
That's correct.
You guys didn't get that far?
No, we didn't.
Okay.
Not at that point.
And then after you remove his hand, what happens after that?
I moved his hand. That's when I grabbed his other arm, because that's when my coworker had his leg, and he was saying, let loose my leg, and that's when he started flailing.
Okay.
And he hit me, and yeah, that's when it started.
And he hit you?
Yeah, he reached back, and then he kicked at the same time, and that's when everything kind of just started.
And for the record, you put your hand up in the air and you had your hand in a closed fist. Is that indicative of what he did that day?
Oh, yes, yeah.
Oh, with a closed fist?
Yes, it was well backwards.
Did he make contact with you?
Yes, right into my chest.
All right. At that point in time, is he now a danger to himself or others?
Yes.
All right. With the presence of law enforcement at the hospital, what is your understanding of your relationship between you and law enforcement?
We have the lead. We are the lead, and then they're basically there just to back us up if anything goes awry, goes a little too far, if we can't handle it ourselves.
Is it fair to say that the security officers are the ones with authority to
Yes.
either trespass somebody or remove them from the property?
Right. We're the one to tell them go ahead and trespass them, or
Okay.
if we want to press charges and everything.
All right. No further questions.
All right, Cross?
Just a moment, Your Honor.
All right.
Thank you, Your Honor. Good afternoon, Mr. Davis.
Good afternoon.
So you work for Allied Universal Security Services.
Yes, I did.
Did you say it was about 10 months that you worked there?
Yes, it was worked for 10 months, yes.
And what was the reason for your departure from that employment?
I actually fell asleep at a post in Stark.
In where?
In Stark.
In Stark? Where would that location be? Or like the
North of
posting that you
Gainesville.
were at?
Oh, it's the emergency center.
The emergency
room.
center, is that associated with a hospital or is
Yes.
it standalone?
It's HCA standalone post.
Okay. That incident in Stark, was that before or after October 2024?
That was in November.
November of 2024?
Yes.
Okay. And so at the time between October and November 2024, you had been assigned to multiple locations to perform security?
Yes, we all have.
We all, and when you say we all have, do you mean yourself and Mr. Hanley or
all the
all of
staff.
the,
Yeah,
all
because they're
security?
short, yes. Like the one they've been out on Archer Road, that one is needing people. So they constantly, if they can't hire no new people, they send people to cover them posts and make overtime.
Okay. I'm sorry, I think I misheard the word you used. You said something people, and they need to hire more people. What was that word you said?
No, when they need to hire more people, just when they need to hire more people, they send people out to different posts and
Okay,
make
so,
overtime.
so yourself and your other security guards at,
Oh, yeah.
at the team, you would be assigned to different locations, not just to North
Not just-
Florida Hospital?
Yeah. Neil Hopper is one, of course, Stark, and it's one off of 39th somewhere, too. So it's like 3-4 locations in Gainesville.
Okay. And you said that includes not just yourself, but the entire security guard team?
Oh, yeah.
How many people would you say that is?
We focus on your stand your ground hearing.
Yes, sir.
Okay.
So, Mr. Davis, you are an employee of Allied Universal, you said,
Yes, it was.
and you're a licensed security guard under Chapter 493,
Yes.
meaning you are subject to discipline should you violate the rules that you are licensed under,
Yes.
including use of force expectations.
Oh, yes.
And for example, if you were to have physically touch or use force on a person other than protecting yourself or others, that would be grounds for discipline.
If it was out of bounds of what we could do legally, yes.
While you were interacting with the individual on October 30th, Sergeant Loramil of GPD was present with you.
Yes. Well, first 10 minutes, about 10 minutes, she wasn't there. Then we had to call her in because we was thinking we might have to trespass him, and she has some restraints and stuff that we don't have. After you get past level 3, we can't do nothing else. The level 4 is level 4 you get to use OC spray, which we don't carry, not able to carry. Level 5 is taser or baton. We're not able to carry that either. And level 6, of course, is deadly force, which we definitely don't have guns.
Yes, sir.
And that's the 6th level. So once we get past level 3, we basically call in Lima 1, well, GPD. We call it Lima 1.
And when you say levels, you're talking about after
Use
you
of force.
discuss the paperwork,
Mhm.
then you call in an officer?
Yes.
Okay.
Discuss the paperwork, and yes.
Okay. All right, and you said both yourself and Sergeant Loramil discussed providing a ride to this individual?
Yes.
Okay, and at the time you entered the, excuse me, let me back up. This TV here to our side has a still image from a body-worn camera video. Is that yourself in this video?
Yes, that's me.
Have you seen this video before?
Yes, I've seen it.
And at the time that you enter the hospital room while on this video, at that time and from then until ultimately this individual is arrested, you did not offer assistance in getting out of the hospital bed.
Yes, I did, because he had everything. He had his crutches right there and everything else, and we were just telling him, you know, hey, you have to leave. We can't just let you stay here.
So if we were to watch this video, we would see you telling him that, to offer him the crutches?
It was before she got here.
Okay. But
Yeah, 'cause that was the verbal part. That's level 2. You go verbal, just to try to de-escalate it. Just, hey, you know, just calm your voice down. And we have other patients that's sick, and you know, you're just gonna have to. You got to discharge. You have to leave. And then we asked him, do we need a ride and everything else. And once he keep going around in circles, we call for Lima 1, well, GBD.
You were present with Officer Loramil while she was offering this individual a ride?
Yes, I was standing there.
And you were able to hear that conversation?
Yes.
The individual was agreeable to going somewhere else?
No. He said he didn't want to go to where that we could offer him, as far as in, you know, if you want to go to Vista or somewhere else medical. And he said no, and he said he had nowhere to go. He's homeless, that's what he said.
But he was willing to engage in the conversation about where he could go?
That was the round part, because we never got past where.
Mm-hmm.
You know, so that's why it was like, okay, well, I guess we just gonna trespass him and sit in the, you know, if he comes back on the property, he'll have to go to jail.
So, my understanding that at that moment, before you went in to the hospital room, you had told him he would be trespassed?
No, I told him, well, I said, you know, do you want to leave? You know, he told me, yeah, well, he got somewhere to go, like where? He said, nowhere, I'm homeless. So then we just kept explaining to him, you know, but you have to get out of here. You can't just stay here. You know, and then we got to the point where we said, well, we call Lima 1, then you may be trespassed, you know, depending on what she can do.
But did you actually request the trespass?
No.
And even though Sergeant Loramil was present and prepared to do so, should you have asked?
Yes, she would have. If we couldn't get him up out the room.
Okay. This was a very short interaction.
Without no violence.
Oh.
I was just saying without violence, of course. But once he struck us, then that's battery, so he had to get arrested again, but yeah.
But moving back to when you enter this hospital room and Officer Loramil is present there with you, there's a conversation ongoing about where the individual can go to, correct?
Yes.
And there is not a statement saying, I'm not leaving at that particular time.
She asked him again. She asked him, we were done talking to him at that point. She asked him again, you know, well, I can take you somewhere, you know, to Vista. He said no, and that's when I think he made again the statement, because they don't give narcotics. So at that point, we already kind of know from dealing with this kind of situation, they just want narcotics. And the behavioral health unit told him no. So that's why they basically refused to be discharged.
But while you were present with Sergeant Loramil,
yes,
having this conversation, there was not a statement saying, I'm not going to leave.
Did he say he's not going to leave?
After Sergeant Loramil had entered the area.
No, he just said, I don't got nowhere to go.
And instead, he had engaged with Sergeant Loramil with that conversation about where he could go.
That's what he verbally said. Yeah, he said, nowhere to go.
Did Sergeant Loramil at any time offer assistance in getting out of the bed?
No. because they don't get hands-on until they actually see us need help. Then we can say, you know, can you grab whatever we need help at.
And prior to entering the room and performing what you called soft hands, I believe?
Yes.
You didn't warn the individual what was about to happen, what you were doing at that moment.
I said, come on, you're gonna have to go. You're gonna have to get up out of here. That's what I said.
And that was prior to entering the room, if
That was
if I recall.
walking in the room, pulling out the bed rails.
Mm-hmm.
That was it.
I'd like to return to the medical records that you discussed a few minutes ago. Your Honor, may I approach the witness?
You may.
I'm looking at the same page 4 that you had looked at with the Assistant State Attorney earlier. Do you agree this is the same page?
Your Honor, I'd ask the attorney to use the medical records that are in evidence just to make sure we're on the same page.
May I approach the clerk?
Yes.
So I'm showing you what has been marked in evidence as State's Exhibit 2 that you reviewed just a few minutes ago. Is this the same page 4 that you had reviewed with the State Attorney?
Yes.
And at the top it has the bold lettering, discharge plan.
Yes.
You discussed a timestamp of, it said 1920. Just a few lines down this page. Can you read what this line here says?
Last done 10/30/24, 1929.
I apologize. This few words that precede that statement.
Deposition. DC TX ADM LPT.
And then, what's that word again?
Which one? Oh, disposition.
Okay. So
That's a disposition.
disposition, last done 10/30/24, 1929.
Mm-hmm.
That's what that says. And then turning to the next page, what does this page appear to be, sir?
I said discharge/care plan.
Down here at the bottom, we have another date timestamp. Can you read what that says?
Documented by user Carrie D. Henderson, MD, 10/31/24.
And it appears there's
2341. Timestamp.
So there are two different timestamps, or three different timestamps on the documents we just reviewed. Is that right?
Yes, that's correct.
It was 1920, 1929 on October 30th, and then there's 2341 on October 31st. You don't personally know at what time discharge happened?
On the day that I was there?
Yes, sir.
Oh, it was the day that I was there, yeah. The 9:30. That was the day that I was there. The time I was there.
9:30?
I think it was 9:30. I think it was 19:30, that's right.
I'm sorry, you're referring to the timestamp on this
Right.
body cam video?
Yes.
It looks like it says right now 1938. Is that 06?
Yeah, 06. That's when she got there.
Okay. And you, was it yourself or was it Mr. Hanley who called for Sergeant Loramil to respond?
It was me.
and you did so because you needed law enforcement assistance?
Yes.
And at that time that you called for assistance, there was no threat of violence going on at that time?
No, it was just to basically show GPD is here now. Normally, some people, like I say, deal with it all the time. Sometimes they see a uniformed police, then they act actually accordingly. Sometimes they don't. Sometimes it works, sometimes it don't. They see us, oh, y'all the fake police, so sometimes they don't listen to us. So sometimes you say, okay, maybe we need to get GPD in here. GPD can basically break down the law and tell them the same thing that we've told him, which she did. And he still was saying the same thing, going around in circles. I ain't got nowhere to go. I got somewhere to go, but I ain't got nowhere to go. And she said the same thing, I offer you a ride where you need to go at.
And during that conversation, at no time was there a statement of, let's go ahead and get you over to this other location so we can continue this discussion, right?
No, we just offered him to go to Meridian or Vista. And like I said, he declined that. So, yeah, that was all. Kept going around in circles.
Now, this entire interaction, you said, lasted less than 10 minutes?
When she got there, when I got there, it was at least 10 minutes that went by when I got there. When me and Huntley arrived. When she got there, it had been like 10 minutes by then. So then, that was probably about 5, something like that after she got there. 5 to 10 minutes. When she got there, was basically saying the same thing we were saying.
May I have just a moment?
You may.
No further questions, Your Honor.
Okay, any redirect?
Just one question, Your Honor. Mr. Davis, at any point in time with your interaction with Mr. Bancroft, did you ever threaten him?
No.
No further questions.
Okay, all right, sir, if you have a seat outside, please. All right, state, call your next witness.
That concludes the state's witnesses, Your Honor.
Okay. Defense wish to call any witnesses?
No, Your Honor.
Okay. All right. State want to release their witnesses?
Yes, the witnesses can be released.
So you're free to go, sir.
All right now.
All right? All right, state has the burden, so I'll let the state make first argument.
Yes, Your Honor. At some point, I would like to replay just a portion of the video to this court, just to make sure that the argument is very clear about what the state is arguing. But I'll first start with the case law I plan to rely on. And I have copies for the court as well as defense counsel. May I approach, Your Honor?
Yes.
Yes. Your Honor, and the first case law is Burns versus State of Florida. Citation is 361 Southern 3rd, 372. In the set of facts that we have here, Your Honor, it's a homeowner who's on his land and then has an interaction with a crew of members that are working on his property, specifically in the capacity of, I think they were doing some tree work. But on page 3, it kind of gives a brief description of what happened in the highlighted portion. Burns demanded that the crew members leave his property following their refusal to immediately leave. Burns retrieved his handgun from his residence and openly carried it in his yard while loading it by advancing a bullet into its chamber. I think it's important to note that the court found that his actions were non-deadly, which is why it applies, I think, to this case, Your Honor. After they analyzed whether or not it was non-deadly or deadly, they then found on page 5, in addition, after Burns asked the tree cutting crew to leave his property and they refused to immediately do so, they became trespassers, justifying his legal right to use non-deadly force. Further, it states non-deadly force to assist him in not only terminating the trespass, but also in preventing the reasonably perceived tortious and criminal interference with his dogs, which were also on his property. That is the main case law that the state is relying on in this case. The second case that was provided by the state is Edwards versus State. Citation on that is 257 7th 3rd 586. And all that defines is just what the clear and convincing standard is for this court to consider. The main focus that the state would like the court to take into consideration is that the trial court applied the correct standard weighing the conflicting evidence and determined the credibility of the witnesses in reaching its decision. And that's what we're asking the court here to do. We recognize that there was a prima facie case set up in their motion. However, a few things that the state would rely on in showing that it has reached its burden and clear and convincing. Number one, that the defendant, in the defense motion, they state that Mr. Bancroft believed he had not been discharged and told officers that he had not yet seen a psychiatric doctor. That has been disputed by the facts here today, Your Honor. You not only heard testimony from both security officers, but we also have his medical records indicating that there was a time of decision for discharge at 1920. Further, in the body cam video provided to the court, we hear communicated to him several times, both by the security officer and Sergeant Loramil, both with knowledge of his discharge, that he is no longer allowed to stay there. I believe this is enough to overcome the facts that they laid out in their motion. The second portion that the defense states is that Mr. Bancroft remained agreeable to leave the hospital. And again, I believe that the testimony as well as the body cam refutes that fact, is that sure, he was willing to go somewhere, but the point is he was not willing to leave that bed. He was not willing to leave that room. He was not willing to leave those premises. At that point in time, when he's going round and round in circles about the same thing over and over again, he's essentially stalling. He's stalling his physical leaving of that room and those premises to go off the property and no longer occupy that bed. So I think the state has overcome that fact as well. And again, I think this is a portion where the court has this in video. I have no objection to reviewing it in chambers as long as defense counsel doesn't. But I think what's important to note is at the time that they enter that room, you hear a couple of things happening. You hear Security Officer Davis tell the defendant as he's going up to the side of the bed rails, hey, you're going to have to go ahead and go. That can be heard on the camera, or excuse me, on the video. You see Security Officer Hanley go to the other side of the bed, and he is successful in putting down those handrails. Then he sees that Officer Davis is struggling with his side. He realizes it's because the defendant, who I might add, this entire video, you can see the defendant has his leg in the same position where he is unable, or is he preventing that side of the handrails to be put down. But when Security Officer Hanley recognizes this, he then goes on to the side of Security Officer Davis and in order to move the foot out of the way to simply put the railing down. And you heard both Security Officer Hanley and Security Officer Davis state that was so that he is not harmed, so that Mr. Bancroft is not harmed. At that point in time, based on the case law, Mr. Hanley has the appropriate, or is within his legal authority to move his foot away from the handrail in order to put it down. When he does so, we do see that he continues to hold on to that leg, but that is because in the video you hear Mr. Bancroft threaten him. He says, I will hit you, I will kick you. And so that is why Officer Hanley explains that he still has a hold of his leg, because as you can see, he's still in a position that if he were to follow through on that threat, he could easily kick him. he does not let go of the leg until he is securely on the side of the bed, away from his leg where he feels he would be out of danger. Even still, as soon as he lets go, the defendant then kicks him, and not just once. He continues to kick him, or attempt to kick him. And that is where we see Security Officer Hanley then grab his leg and attempt to now defend his self. And at another point in time, we also see him let go of the leg, again to try to de-escalate the situation. He puts his hands up, and the defendant continues to kick him. At no point in time was the defendant going to stop kicking him until he was detained. We then see Security Officer Hanley grab the leg in order to secure it from continuing to kick him. Once he does that, we hear descriptions from both Security Officer Hanley and Security Officer Davis that the defendant then ends up biting Security Officer Hanley and spitting on him. And I think it's important to note that the facts in this case are similar to the facts in Burns. We heard testimony from both security officers that they have the authority in the hospital to escort people off of the property who have been discharged but are refusing to leave. It's similar to, they are working well within their capacity and their lawful authority to do so. It's similar to if a business owner had a patron of a restaurant. The patron then becomes overly drunk and disorderly, not necessarily threatening other patrons, but at the same time causing a lot of excitement, or maybe he's using vulgar language. The business owner has the right to escort him off the property using non-deadly force. And I would describe that simply him taking his, Security Officer Hanley taking the defendant's foot and removing it from where it's intertwined from the side rails of the gurney is minimal force. Technically we have to use the word force, but I wouldn't even describe it as force. It's simply to move his leg so that they can then get the side rails down from where he's at. We even hear Officer Davis tell him that you got to move your leg on the video as well. So they are communicating to him as they are talking. It is only at that time that the defendant threatens Security Officer Hanley, in which case he keeps his leg on, or his hand on the defendant's leg in order to keep him from kicking him. And again, I believe that Security Officer Hanley is acting within his authority to do so, both as an authoritative figure of the hospital who has the right to escort people off the property. He has not used deadly force. He has used non-deadly force, and he has done so to a trespasser, because now at this point in time, with him refusing to leave, he has now become a trespasser on this property. And so that justifies his right to use non-deadly force in this situation. And so because of that, the motion to dismiss should be denied.
Okay, defense.
Yes, Your Honor. Starting with the factual disputes identified by the state, that Mr. Bancroft believed he had not been discharged and told officers he had not yet seen the psychiatric doctor. The body camera and evidence reflects this statement exactly. He says to the security officers, sometime between 7:30 and 7:31 that evening, that he believed he had not been discharged and that he had not seen the psychiatric doctor. I will note for the court, Officer Loramil on this body camera, we see she arrives to the area at 7:28 p.m. And there are multiple timestamps listed on the discharge paperwork, one at one time and one at 7:29. I believe it was 7:20, but it does note time of decision. It does not indicate time of communication to Mr. Bancroft. I would offer to the court that Mr. Bancroft was unaware that he...
Did Mr. Davis testify that he actually showed the papers to your client and told him he was discharged?
He did, Your Honor.
Okay. And your client did not testify?
That's right.
So I can only go by what I've heard in the hearing today.
That's understood. Even still, Your Honor, even assuming that Mr. Davis had shown discharge paperwork to Mr. Bancroft, that happened within minutes within minutes before this whole incident happening. not enough time. It would offer to the court that within minutes is not enough time for Mr. Bancroft to have reasonably gotten up on his own.
Well, didn't they say they did all this before the officer's body camera, and that they tried to show him and tried to get him to agree, and when he kept refusing, so it's not as short as this body camera, this has gone on for longer than the time of the body camera.
And that is why I identified to the court the timestamps. Because if the court is to believe that Mr. Bancroft was discharged at 7:20 p.m., then the sum and total of this entire interaction is less than 10 minutes.
How long have he told, you're discharged, you need to go, you're disrupting the emergency room, we need this for other patients? Do you need more than 10 minutes? Most folks, I was at the emergency room the other day with a family member. When we were discharged, we were happy to go. We were out of there in seconds, so.
Yes, sir. I think there is something to be said that Mr. Bancroft is an individual with one leg. He has had a full hip.
How so? They offered to get him a wheelchair, they offered to get him a ride in the taxi. It appeared from the evidence that I saw, it's clear his concern was he was willing to go if they would send him someplace that they could get narcotics, and he didn't want to go any place unless he was assured that he would get narcotics. So I'm not sure how he has one leg. They weren't rushing him out. So how is it that he has one leg is in relationship to the amount of time to get him out when he's refusing to go?
The position of the defense, Your Honor, is that Mr. Bancroft was not refusing to go, that he was engaged in a conversation with Sergeant Loramil about exactly the subject of departing the hospital. It's our position that Officer Loramil, or Sergeant Loramil, by virtue of having that conversation in the presence of these security guards, that she made an implied consent for Mr. Bancroft to remain in that hospital bed during that conversation. Unfortunately, the officers moved in and took him down prior to that conversation ending and prior to reinitiating in order to depart the hospital or an offer of assistance to depart the hospital. We do not see next to the bed in this video, we do not see any wheelchair or any crutches immediately next to the bed. I can't say, Your Honor, but I would argue that had those items been offered within minutes of this video happening, we would have seen those in the area. I also believe we would have seen an offer or rolling of a wheelchair or crutches up to the side of the bed for the purpose of assisting
I agree. If he
Bancroft.
had agreed to go, I think you would have seen one show up.
And our position, Your Honor, is he did agree to go. Unfortunately, that conversation was cut short with Officer Loramil.
Okay. All right.
And we see that in this body camera video that Mr. Bancroft was agreeable to leave when he asks Sergeant Loramil if she will transport him somewhere else. And it's clear that the initial suggestion of going to Meridian was not viable. Mr. Bancroft was still willing to go somewhere else.
Somewhere where they had narcotics. I didn't catch that.
While they did not have an opportunity to finish that conversation, and it was not made explicit that Mr. Bancroft was seeking narcotics, I understand that was the conclusion of the witness. It is not clear that he, in fact, was present just for narcotics or trying to get narcotics.
Okay. All right.
He remained agreeable to leave, and within moments he was grabbed and restrained. He did attempt to indicate to the security officers that he did not wish to be touched. He made a clear statement that he did not wish to be touched. Admittedly, it was not the nicest way to make that statement, but he did clearly indicate he did not wish to be touched. At that point, the officers escalate the encounter, attempting to drag him out of the bed, forcibly manipulating his one leg in ways that Mr. Bancroft is unable to then move his leg, and in ways that could potentially injure his hip and lack thereof. Our position, Your Honor, is that the security guards have a right to ask people to leave. Those people do have a right to leave on their own. They also have an opportunity to, should have an opportunity to leave on their own. The discussion with Officer Loramil amounts to an implied consent to remain in the hospital bed for the purpose of that conversation about where they were going to go. And it is the defense position that had that conversation been allowed to conclude, that the attempted takedown or the takedown of Mr. Bancroft would not have been anywhere close to perceived as necessary.
Okay.
I would like to offer to the court a case on the issue of implied consent. It is Corey Stephen Smith versus State of Florida from the 6th District Court of Appeal. It did recently publish in the Florida Law Weekly under 50 Florida Law Weekly D1403A. Do you have a copy for the court? Unfortunately, do not have a separate blank copy for the state.
Did you highlight by chance what you want me to focus on?
Yes, Your Honor, I did to the copy I just handed to the state, if I may approach.
Okay. If you want to trade, I'll trade you.
Yes, sir. On page 3 of 12,
If you need that to refer to first and then hand it up, that's fine too.
okay.
And I guess I glanced at it. Is that case law that there should have been a self-defense instruction given?
Yes, Your Honor, it is on the issue of self-defense instruction in regards to deadly force being used.
Okay.
It does include discussion about a homeowner in which the homeowner had instructed the defendant or the appellant, Mr. Smith, to leave the premises, but had engaged in conversation in which there was an agreement or an offer to allow him to collect his items and then leave. And the court in this case finding that even if the permission to be on the property was initially revoked, the invitation to get his items was converted the scenario to being an uninvited licensee. For that, Your Honor, I would refer to page 7 of 12. Under subsection B.
All right. All right, anything else?
Yes, Your Honor. The court will be able to see in the submitted medical records that Mr. Bancroft had been present for a Baker Act earlier in the same day on the date of this incident. An individual under Baker Act generally is presumed to be in a different state of mind than an average person out in the community. And I think that's important because when we're considering the reasonable person standard in the light of what the person at issue knew at the time, we knew Mr. Bancroft is an individual with one leg, a removed hip, and he is agreeable to leave the hospital He's being faced with two individuals who are physically more able than him and are physically above him as he lay in the hospital bed. He is distracted and engaged in a conversation with Officer Loramil about where he is going to go next. And before he has an opportunity to find out what is going on, the security officers place their hands on him, and he responds, attempting to defend himself because he doesn't know what they are about to do to him. They then grab and pull him down the side of the hospital bed and press his legs forward, hold him down for several minutes, continuing to interact with him and use force on him. It is our position, Your Honor, that Mr. Bancroft was defending himself from excessive force by the security guards, and that at the time that they went to remove him from the hospital bed, Mr. Bancroft was owed an escort, and he was not owed a takedown. They were not entitled to physically drag him out of that hospital bed when he was willing to leave on his own accord. He should have been offered the opportunity to do so, and unfortunately was not. I would ask the court, as the fact finder, and after hearing this testimony today, to find that the state has not met its burden of clear and convincing evidence that Mr. Bancroft did not act in self-defense.
All right, so the court, after reviewing the credibility of the two witnesses who testified, watching the video and the evidence of the discharge papers, finds that the state did meet its burden by clear and convincing evidence that he's not entitled to immunity. They attempted to nicely ask him to go. They attempted different levels. Ultimately, they had to call in law enforcement, and the defendant continued to refuse to leave. So I'm going to deny the defense's motion. I'll have to get an order. So I'll put on the record now, and I'll follow up with a written order. So in case down the road, if you need to appeal, there'll be a written order.
Yes, sir.
Okay, all right. So you said something about next week's trial.
Yes, Your Honor. The defense has a subpoena that is currently pending with the due date of this weekend on Saturday, August 30th. At this time, we do not know if we will receive the response by that deadline, but
You have a subpoena to whom for what?
to Allied Universal Security Services for a written copy of their use of force policies.
Okay, so this case is 302 days old and has been set for trial multiple times. Set for trial in July, set for trial this month, I think. So I understand you may have waited to the last minute, and I don't see that as a reason to continue the trial. The trial goes all the way, jury selection will be on Tuesday, and the trial is scheduled for Friday.
Yes, Your Honor. The other basis would be at this time, the defense would move to continue the trial to the next trial term so that the defense can obtain a transcript of today's hearing for use at said trial.
If you want to bring in your own and have someone do it all weekend at the expense of the public defender's office, you're more than willing to. More than that. You have all the way till Friday to get the transcript, once again. So I don't think and your client's been in custody this entire time. I'm sure he's ready to get a decision one way or the other. So I'm going to deny it for that as well.
Yes, Your Honor.
Okay? So we'll see you back Tuesday morning for jury selection?
Does Your Honor have a few moments that we can speak with our client before
Yes.
the court leaves?
Yeah, we'll be at ease.